Parties president. Parties. Parties are absent.
You're muted if you can hear me. You're muted. I don't know, but may it please my lord, OJ Ajoku humbly appears for the first defendant. My appearance, I appear with CE Ongmer, my lord.
OG.
J as in Juliet.
OJ. Okay. Yes, OJ what?
Ajoku. My lord, Ajoku is spelled AJOK.
Yes.
My humble appearance is for the first defendant. My lord, I appear with CE Ongmer, my lord.
With CP.
Ongmer. My lord, Ongmer is spelled ONWMER.
Yes. For the first defendant.
For the first defendant, madam.
Yes. Yes. Is second defendant present online?
It appears he was, but it appears he's no longer here, my lord.
Out of the claimant.
I think I saw a name here. I saw an appearance here, but there was no name. So we were just assuming it was the claimant, but I don't think they are still here.
Registrar, please put a call on them. Time was given and I was unable to see.
For the second one, it's fine.
Okay.
Yeah, the next one is trying to reconnect it. Because of this one.
Send the claimant a text message again.
I've sent.
The issue is that there has been a delay. If not, I will not include that issue. Call them. Yes, is the second defendant connected?
Barrister Ben, are you there? Listen. Just a moment. Barrister Ben, can you announce your appearance, please?
Respectfully, my lord.
Yes.
I am Ben Uzozie.
Yes.
I appear for the second defendant.
Yes. Yes, Registrar. No contact with the claimant's counsel.
His line is no longer connected.
And no other alternative line. All right, they are aware of they were given the passport. So the matter is for judgment and is ready. This suit was filed by originating process on the 22nd day of September 2023, where the claimant, that's the first and second claimant, filed an action against the defendant. The first claimant claims against the defendant the following relief. 1. A declaration that the first plaintiff, upon being stopped from returning to work by the defendant through phone call on 31st March 2021 on redundancy, is entitled to the statutory redundancy benefit provided by law in Nigeria and should be paid them immediately. A declaration that the letter of termination served on the first plaintiff on the 7th of July 2021 was unlawful, illegal, and did not follow due process of law, having not given the plaintiffs the statutory notice of payment in lieu and violated the service contract and the first defendant's collective bargain agreement with senior staff in its employment. 3. A declaration that the first and second plaintiffs are employees of Total E&P Nigeria Limited, the first defendant, and are entitled to the same benefit as its other employees of the same position and category of contract staff of the first defendant. An order of court for payment of the sum of 100 million naira to the first claimant by the defendants jointly and severally for unlawful termination from the first defendant after 15 years of meritorious service of the first defendant. An order of court for payment of salaries and entitlement of first claimant for the month of April, May, June, and July 2021 being unpaid salaries until the month of July 2021 when the defendant served the termination letter to the first claimant. An order of court for payment of 5-month remuneration entitlements due to personnel that have spent 10 years and above working for the company. An order of court for payment of 20% of his total annual remuneration multiplied by 15 years being the total number of years the first plaintiff has spent working for the first defendant company, a redundancy entitlement. An order of court for payment in whole and in block of first plaintiff's statutory pension contributions made by first plaintiff through deduction of 5% from his monthly salaries by the defendants, and another 5% statutory contribution by the first defendant in favor of the first plaintiff amounts to 10% pension contribution of the first plaintiff for 180 months of 15 years. An order of court for payment of the sum of 200 million naira as general damages, suffering, prostrations, anguish, pains caused the first plaintiff and members of his family when the defendants denied and withheld his entitlement due him after 15 long years of meritorious service and working for the first defendant. 20% interest per month on the entire judgment sum until liquidation. Second claimant's claim, a declaration that the second plaintiff, upon being stopped from returning to work by the defendants through phone call on the 31st March 2021 on redundancy, are entitled to the statutory redundancy benefits provided by law in Nigeria and should be paid same immediately. A declaration that the letter of termination served on the second plaintiff on the 7th of July 2021 was unlawful, illegal, and did not follow due process of law, having not given the plaintiffs the statutory notice or payment in lieu and violated the service contract and the first defendant's collective bargain agreement with senior staff in its employment. A declaration that the first and second defendants are employees of Total E&P Nigeria Limited, the first defendant, and are entitled to the same benefits as its other employees of the same position and category of contract staff of the first defendant. An order of court for payment of the sum of 150 million naira to the second claimant by the defendant jointly and severally for unlawful termination from the defendants after 28 years of meritorious service. An order of contract for payment of salaries and entitlement of second claimant for the months of April, May, June, and July 2021, being unpaid salary until the month of July 2021 when the defendant served the termination letter on the second claimant. An order of court for payment of 5 months of remuneration entitlement due to personnel that have spent 10 years and above working for the defendant. An order of court for payment of 20% of second claimant's total annual remuneration multiplied by 28 years, 1993 to 2001, 2021, being the total number of years the second claimant has spent working for the first defendant as a redundancy entitlement. An order of court for payment in whole and in block of second claimant's statutory pension contributions made by the second plaintiff through deduction of 5% from his monthly salaries by the defendant and another 5% statutory contribution by the first defendant in favor of the second plaintiff, amounting to 10% contribution of the second plaintiff for 336 months of 28 years. An order of court for payment of sum of 300 million naira as general damages for suffering frustration, anguish, pains caused by the second plaintiff and members of his family when the defendant denied and withheld his entitlement due him after 28 long years of meritorious service and working for the first defendant. Finally, 20% interest per month on the entire judgment sum until liquidation. Upon receipt of originating process, parties, that's the defendants, file their responses by filing their memorandum of appearances and statement of defense on the 17th January 2025. The trial commenced in this suit on the 30th of October 2024. CW1, the first claimant as CW1 and second claimant as CW2 all testified and tendered documents marked as exhibit C1 to C32. They were all duly cross-examined by the defendants. The first defendant opened his case, called his witness as DW1, but did not tender any document. The witness adopted his written deposition and was duly cross-examined. The second defendant also opened his defense, called one witness and tendered two documents marked as exhibit DW1 and D1, D2, respectively. Parties filed their final written addresses, and on the date of adoption, parties highlighted all the processes, filed and adopted them, and urged the court to grant their respective reliefs. Issues for determination. The claimant in his written address, final written address, submitted 5 issues for determination. The first defendant submitted 2 issues for determination, while the second defendant submitted one issue for determination of this suit. I have carefully examined the set of issues submitted by parties. I am of the view that the following issue can conveniently determine the matter. That is, whether from the facts and evidence adduced by the claimants have established their case to entitle them the relief sought. The facts of the case, that is the claimant's case, the defendant's case, are all as in their respective pleadings. I only summarize them. Then the arguments, the legal submissions of the parties are also in their final written addresses, and I all summarize them. Time will not permit me to read all those lengthy ones. I will go straight to the decision. Court decision. I first start with what the first defendant counsel referred to preliminary issue on the jurisdiction of this court in respect of this matter. Learned counsel on behalf of the first defendant argued that first and second claimants filed this suit jointly, yet their respective claims disclose distinct and unconnected causes of action arising from separate employment relationships and contract with different facts and timelines in their employment. Counsel submitted that there are several appellate court decisions forbidding person with individual or distinct terms of employment to commence a single or joint action to enforce any breach of their individual contracts of employment. He cited Ogungwa versus Williams, Bemil Nigeria Limited versus Marcus and others, and the decision of this court in Iwari, Okuro and others versus Port-Harcourt Flour Mills Limited. All citations provided and suit number in the last case provided. He urged the court to strike out the suit for lack of jurisdiction over the improperly constituted suit. The claimant's counsel in his response submitted that the preliminary issues raised by the counsel to the first defendant is misconceived and lacking in merit. He urged the court to dismiss it on the following reasons. A, the preliminary objection must be brought timeously. B, the objector, having taken steps and participated in the proceedings, has waived his right and cannot turn around to raise objection. C, misjoinder or non-joinder of parties does not invalidate a suit. He cited various authorities, which I reproduce here in the judgment, to support his points raised in this response. In our civil proceedings, in our civil procedure, we have two forms of joinders, joinder of parties and joinder of cause of action. It is true that joinder, misjoinder or non-joinder of parties in the civil suit does not invalidate the suit. See Order 13 of the National Industrial Code Civil Procedural Rules 2017. The essence of joinder is to unite to that action all persons who have the same rights or against whom rights are claimed as either co-plaintiffs or co-defendants. The party joined should be bound by the result of the action. The question to be determined in the action must be such that cannot be effectively and completely settled unless the person sought to be joined is made a party to the action. The test is whether the person to be joined will have his interest irreparably prejudiced if an order joining him is not made. See Imagu versus Asibelu, Union Beverages Limited versus Pepsi Cola, all citations provided. In the instant case, the two claimants are on all fours distinct from one another, as pointed out by the first defendant's counsel. They have different facts, different reliefs, all arising from individual contracts of employment with the defendant. This rendered the action incompetent. It is not an issue of mere irregularity. It goes to the jurisdiction of this court to entertain the matter, having been not properly constituted. See the cases of Bemil Nigeria Limited versus Marcus, Emirebe and others rightly cited by the first claimant's counsel. Also the case of Bossa and others versus Julius Bayer PLC, CCB Nigeria PLC versus Ross, all citations provided. Claimant counsel raised issue of not bringing the objection timeously and was brought after the objector had already taken steps in the proceedings. The incompetency of this suit is not one of mere irregularity, but one that touches on the jurisdiction of the court. Issue of jurisdiction is one that has no limitation and can even be raised for the first time on appeal. It is the live wire of a case which should be determined at the earliest opportunity. If a court has no jurisdiction to determine a case, the proceedings remain in nullity, no matter how well conducted and decided. This is so since defect in competence is not only intrinsic but extrinsic to the entire process of adjudication. See the case of NURTW versus RTEN. Citations provided. I therefore entirely agree with the learned counsel for the first defendant that this suit was, as constituted, is incompetent and liable to be struck out. Accordingly, the objection is upheld and suit number NICN/PSC/89/2023 is hereby struck out for being improperly constituted. However, this court being court of first instance I might be wrong in upholding the preliminary issues. Since I have the opportunity of hearing the entire suit, I shall proceed to decide the case on merit, so that on appeal, the appellate court has opportunity of deciding based both on the preliminary issue and the substantive issue, substantive case. From the statement of facts and evidence adduced during trial, the gravamen of claimants are that they were employed by the first defendant, where they worked until they were stopped from work on redundancy in March 2021, and later in July 2021, they were issued a letter of termination of their employment without due process and in breach of their contract and the first defendant regulations and policies. The law is that the burden of proof of establishing a case lies on the party who asserts the existence of certain facts. He must first prove the existence of non-existence of what he asserts by relevant, admissible, and credible evidence. Once the burden is discharged, the onus of proof shifts to the adverse party. The burden of proof of particular facts continue to shift between the parties until all the issues in the pleadings have been dealt with. Also, where a party is seeking a declaratory relief, he must prove it by cogent, credible, and admissible evidence. It must be on the strength of his own case and not on the weakness of the defense. See the cases of Igwe versus ACB, Andrew versus INEC, all citations provided. In a contract of employment regulated by the terms of employment, otherwise known as master-servant relationship, the law is settled that an employee who complains that his employment was wrongly terminated, he has the onus to prove the wrong by placing before the court the terms and conditions of the contract of employment and proving in what manner the said terms were breached by the employer. The terms of contract of service are the bedrock of any case where the issue of wrongful termination of employment calls for the termination. See the case of Porsche versus NGC Limited, citation provided. I have analyzed the proof of claimants, but I will take it in summary. In proof of their case, the claimants adopted their witness statement on oath and tendered documents marked as Exhibit C1 to C23. I have itemized all the documents with their names. From the contents of these exhibits, Exhibit C2, C3, C5, C8, C11, C12, C23, and D1, Exhibit D1, were all contract agreements between the claimants and either the second defendant or PANEF Services Enterprises Nigeria. While Exhibit D2 is a contract for the provisions of Techlog service personnel end of contract notification between the first defendant and the second defendant. It is obvious from the evidence adduced at the trial, particularly the documentary evidence admitted and marked as exhibits. In this case, there is nowhere the first defendant employed or instructed the second defendant to employ the claimant. In my clear understanding, the relationships between the first defendant and between the first defendant and second defendant was one of independent contractor, not an employment or agency. The second defendant is an independent entity as distinct from first defendant. Claimant counsel raised the issue of triangular employment existed between the claimant's first defendant and second defendant. The facts and evidence adduced had not established same. I have deeply analyzed it, but due to time factor, when you get your judgment, you will see all the analysis. The I will go straight to the conclusion. Consequently, it is my opinion that the totality of evidence adduced by the claimants did not in any way establish their pleadings to entitle them the relief sought. Having failed to discharge the burden of proof placed on the claimants, there will be no requirement to consider the defendant's defense, as the claimants have failed to establish their claims by cogent and credible evidence. Consequently, the claimant case is hereby dismissed for lacking in merit and for lack of proof. The sole issues for determination is resolved in favor of the defendant against the claimant. The judgment entered. No order as to cost.
As the court pleases.
Yes,
Grateful.
yes, I held you to this evening because my attention was drawn lately that this 90 days will end tomorrow.
Okay.
So that's why I have to do what I should do to meet up the requirement of Constitution.
Lord, we are very grateful.
All right, thank you. Yes. Yes, that's all. Okay. He joined later. Okay. Okay.